For the record, Mr. McAdall is here for the state, Mr. Glenn, Mr. Manship, Ms. Celadoni are here for the defendant. Defendant's present, and jury's outside the courtroom. Well, the officers brought me a note from Irene Aranda, presumably the foreperson. They put in writing transcripts needed. Jerry Pilarski, Albert Kraniak, Clarence Bennett. Can we have to review their transcripts? Thank you, signed Irene Aranda. Mr. Bacalo.
I think there's an instruction that we can bring them out and replay the testimony for them. So I think just comply with the instruction.
Okay. Defense?
Judge, I would object to replaying the testimony of the certificate aspect.
Wasn't that what they're asking for?
Well, they're asking for a transcript. I have my reasons. I would object to replaying the testimony of the certificate in question.
4.4, Judge.
4.10.
Make sure
3.0.
most recent. Judge, I would request that the court read 4.44, entitled Request for Transcripts, to the jury.
Sorry, which one?
It's 4.4, subsection 4. There's there's 4 different variations of the readback instruction. These are all relatively new. There's a good amount of case law out there that talks about just simply denying the request being error. I don't have it at my fingertips, but it looks like this instruction was adopted or amended in 2013.
Do you have it there in front of you? I don't have it. I don't think. I don't have that one in front of me here.
Here you go.
The jury has requested in writing, they've requested transcripts needed of Jerry Pilarski, Albert Kraniak, and Clarence Bennett. They asked, can we have to review their transcripts? It's signed by Miss Orenda, presumably the foreperson. Bar Rule of Criminal Procedure 3.410 says, after the jurors have retired to consider their verdict, if they request additional instructions or to have any testimony read or played back to them, they may be conducted in the courtroom by the officer who has them in charge. The court may give them additional instructions or may order the testimony read or played back to them. Instructions shall be given, the testimony presented only after notice to the prosecuting attorney and to counsel for the defendant. All testimony read or played back must be done in open court in the presence of all parties. In its discretion, the court may respond in writing to the inquiry without having the jury brought before the court, provided the parties have received the opportunity to place objections on the record, and both inquiry and responses are made part of the record. There's jury instruction 4.4 that applies to this if I agree to this. All right, I will we don't have transcripts available, so I've either have to have it played over the recording system here in court or have the court reporter read it back to them. I prefer to have it played, the audio portion played to them here in court. I think 4.4 covers this. I was going to write them a note telling them we don't have transcripts, but I think I'll read this instruction. This instruction says, members of the jury, you've asked that transcripts of testimony be provided for you. Transcripts are not available. However, you may request to have the testimony played back to you. This request may be granted at the court's discretion. I now direct you to return to the jury room to discuss your request further. If you're not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have the testimony read or played back to you. If you decide to make such a request, it should be as specific as possible. Or I can just have them come in and play it for them. Let me double check the recording system to make sure they can put their fingers on it, their testimony. Okay. Bear with me while we communicate with the recording folks. There's the 3 lead.
Yeah, that might help us. She's working on the times now. You know what I mean? Yeah. No, it's fine.
Let me just go off the record. Let me go check on this audio recording. If y'all can just bear with me just